Hello, America. I'm Mark Levin, and this is Life, Liberty, and Levin Saturday, and I want to talk about Mr. Bobblehead. Now, ladies and gentlemen, Joe Biden got up in front of a microphone like this. He read the lines as best as he could. He started out the other day by attacking Donald Trump, saying he's a dangerous man to attack our justice system like this. He had his day in court. There'll be appellate process. The jury decided. Well, of course, the problem is there was a jury. There should never have been a jury. There should never have been a case. The prosecutor is a Soros prosecutor. Case should have been dismissed. The problem is you have a judge who is a Biden judge. So now you have two individuals, two dishonest individuals who lack complete integrity. That is Bragg and Merchan, who are influencing a federal national presidential election. Joe Biden's fine with that. I'm glad to know Joe Biden's fine with that because apparently Joe Biden believes that that is precedent, what took place in the New York court. He's very happy with it. Just let the process play out. Okay, let's let the process play out. So where are we with the Merchan-Bragg decision? Because it's them. The rules to the instructions to the jury gave an inevitable result. So where are we? Where we are is if you make an effort to influence an election as a candidate to prevent something negative from coming out in order to present a false positive picture, you have then created a criminal event. What's the law? Doesn't matter. What's the intent? Doesn't matter. Yet we actually have intent in the case of Joe Biden. What are you talking about? God willing, if Donald Trump is the next president of the United States, I am going to urge him, I'm going to lobby him to tell his Attorney General of the United States, let's stop playing games, to indict Joe Biden and indict Anthony Blinken. Because according to Bragg, Merchan, Biden, their media, and their surrogates, they committed a crime. In this case, we don't have to even recreate it through some phony link to a federal statute to revive a state statute. We don't need to get into all that stuff. We have federal campaign laws. It doesn't matter which part of the law, even though we have one, because that is the precedent that comes out of the New York case that Biden just supported. Okay, what am I talking about? I have in front of me a letter, October 19, 2020. Public statement on the Hunter Biden emails. It's about the Hunter Biden laptop. You're aware of this? 51 former intelligence spooks from all levels of the CIA, National Security Council, and all the rest of it, signed a letter, the purpose of which was to influence the election. And in the letter, they say, for a bunch of reasons, we write to say that the arrival on the U.S. political scene of emails, that's the Hunter Biden laptop, purportedly belonging to Vice President Biden's son, Hunter, much of it related to his time serving on the board of the Ukrainian gas company Burisma, has all the classic earmarks of Russian information operation. And they go on to make their case. And not only that, they leaked it to the media. Well, who prepared that letter? The letter's a lie. The letter's a lie. The laptop is legit. It's being used in a federal case right now against Hunter Biden. It's 100% legit. The laptop, therefore, was dismissed as a non-issue as Russian disinformation 2 weeks before the election. 2 weeks before the election. In fact, in the final debate, Joe Biden pointed to a piece in the media citing the experts that this was Russian disinformation when it was brought up by Donald Trump. So the fact that it was used, the fact there was an organized effort, the fact that it was a negative story that was squelched to influence the election, there is no debate. I don't need a porn star to tell me that. I don't need a 400-time liar to tell me that. I don't need a crooked judge to tell me that. I don't need a crooked Soros prosecutor to tell me that. I don't have to play with the rules of evidence. I don't have to destroy due process. It's a fact. It's simple. It's open and shut. Game over. Biden and Blinken need to be indicted. God willing, if Donald Trump is president. Let me tell you why. They leaked this letter to a specific report at the Washington Post. How do we know? Because it was testified to that effect to Congress under penalty of perjury by the former deputy CIA director to Obama, Mike Morrell, who signed the letter. And so what happened exactly? Well, first of all, here's one of the stories that took place the same day the letter went out. Here it is, October 19, 2020, Politico, one of the favorite outlets for the Biden regime. And it says more than 50 former senior intelligence officials have signed on to a letter outlining their belief that the recent disclosure of emails allegedly belonging to Joe Biden's son, quote, has all the classic earmarks of a Russian information operation. And the story was planted. The outcome was the outcome they wanted. Right, Joe? Yeah, I think so, bobblehead. But what else do we know? Wall Street Journal opinion piece summed it up nicely. April 23, 2023. The House Judiciary and Intelligence Committees released portions of a deposition transcript exposing the origins of the statement from the 51 former U.S. spies declaring that Hunter's laptop had, quote, all the classic earmarks of a Russian information operation, unquote. The admission came from Mike Morrell, former deputy CIA director under Barack Obama. The letter served its political purpose of giving the media and Joe Biden the opening to dismiss the New York Post laptop scoop on Russian disinformation. Turns out the Biden campaign was behind the letter. Okay, case closed. But I got more. Mr. Morrell told Congress under oath, under penalty of perjury, that he received a phone call from Antony Blinken. Last time I checked, he is our pathetic Secretary of State. On October 17, 2020, 2 days before the release of the letter, and 3 days after the New York Post published emails from Hunter Biden's laptop. Why were those emails important? Because they implicated Joe Biden in illegal foreign business schemes to get money from the communist Chinese. Mr. Blinken was then a senior advisor to the campaign and now Secretary of State. The letter says Mr. Morrell also, quote, explained that the Biden campaign helped to strategize about the public release of the statement. So they organized it, they drafted it, they had the entire process set up to get it to certain reporters. And I admit it wasn't the National Enquirer, but it's worse. It went to all the mainstream radical Democrat Party media and was pushed out. Mr. Morrell says he then contacted an aide to former CIA Director John Brennan to say, quote, the Biden campaign wanted the statement to go to a particular reporter at the Washington Post first, and that he should send the statement to the campaign when he sent the letter to the reporter. Mr. Morrell acknowledged he had two goals with the statement to, quote, share our concern with the American people, unquote, and to help, and I quote, Vice President Biden win the election. All this took place shortly before the final presidential debate. Mr. Biden pointed to the Gang of 51 statement that his campaign helped to generate as proof that Hunter laptop was phony. Quote, look, there are 50 former national intelligence folks who said that what this is, President Trump is accusing me of is a Russian plan. They have said that this has all the characteristics. 4 or 5 former heads of the CIA, both parties, say what he's saying is a bunch of garbage. They create the letter, they get it signed, they leak it to media outlets who are happy to support him. They want him to win. Then he cites his own dirty work. To what? To influence the election. Even if he didn't have intent, it doesn't matter, according to Mr. Merchan. That's why this is an open and shut case. Mr. Morrell told the committee that following the debate, Biden campaign chair, now senior White House aide, Stephen Ricchetti, called to thank him for the statement. No doubt the Biden campaign had in essence generated its own disinformation, marshaling the authority of supposedly nonpartisan intelligence veterans to discredit a story that was accurate about laptop emails that were authentic. We don't even need to play around in state court. We don't even need to go through the motions of breathing life into state misdemeanor statutes. They need to be revived because the statute of limitation has run. No. I'll just point to the Federal Election Campaign Act. What part, Mark? I would point to the in-kind contribution part, but I don't have to point to any part. That's what happened in the courtroom. And Biden says it's a great process. Joe Biden and Antony Blinken, God willing, if Donald Trump is president, must be indicted if we're going to have an equal application of due process, or in this case, really no due process. That's what needs to happen. But we have another problem for Joe Biden, for which he needs to be indicted. We have a special counsel report by Mr. Hur that says he willfully disclosed classified materials. I quote. In other words, he violated the Espionage Act. Now, when he violated the Espionage Act, he wasn't president, so there's no presidential privilege that you can assert, or you can't assert that as head of the executive branch, he's immune from such prosecutions, which I think he would be, just my own view. But his violations occurred when he was a U.S. Senator, when he was Vice President of the United States, and when he was a private citizen. He got an $8 million book deal. In other words, he got $8 million for spewing classified information about Afghanistan meetings. That's a crime. If anybody else did it, it would be a crime. Now, Joe Biden believes in the rule of law, so let's stick with the rule of law here. The fact of the matter is that you can indict a president after they become president for actions they took having nothing to do with his presidency. That's not even what's up before the Supreme Court on immunity, which is the actions of a president when a president leaves. This is about the actions of a president before he was president, when he was vice president, when he was a private citizen, when he was a senator. Now, what about the statute of limitations? They don't matter. We have a case in New York. Statute of limitations? What statute of limitations? For goodness sakes. We just believe in getting to the bottom of this. We have so much evidence in this report from Mr. Hur of willful violations of classified information, it's hard to keep track. I know, but the Department of Justice said they're not going to act because Mr. Hur said and certified that Joe Biden is an imbecile. And plus, you can't indict a sitting president. Well, number one, he's no longer a sitting president. And number two, the imbecile defense is not one that a Trump attorney general has to accept. In fact, I've never heard of an imbecile defense before, but we have it. It's a first-timer. So Joe Biden is exposed, and in my view, should be indicted for willfully disclosing classified information, effectively selling secrets for a profit, and trying to cover it up. What do you think of that, Joe? Now, one other issue while I'm here, we have two great guests, John Yoo and Leo Terrell. Stick with us tonight. I do not understand the resistance or the confusion when I make the point that you cannot allow the case in New York to stand. Because the case in New York stands for what? Not just lawlessness, not just a violation of the Federal Bill of Rights as applies to the states through the 14th Amendment, and not just a violation of a presidential candidate's former president, the Republican putative candidate, and his due process and equal protection rights, although that would be bad enough. We the people have suffered. We the people have been attacked. The campaign process that's been in place since the beginning of the Republic has been altered by a Soros prosecutor and a Biden conflicted judge. Now, does the whole country have to abide by that now? And they did it through all kinds of schemes and lies and censorship that took place in that Star Chamber. The appellate court process in New York is not sufficient. Whatever they rule, it's going to be too late. That's number one. Number two, an appellate court process in a state should not determine the impact on a federal campaign under federal campaign law on a federal presidential campaign, whatever they decide. So the process has already been breached. The jurisdiction, the Constitution has already been breached, regardless of what the New York appellate court says. This needs to be put back in the box. Now, there's only one entity can do it. I heard somebody say, well, we got to get it into the federal district courts and the second court. That's not right. In fact, that's not even possible. Well, we got to wait to the end of the state court process, but you wait to the end of the state court process, then the constitutional issues are destroyed. We've had people here say, brilliant lawyers, and they're right. All these issues that are relevant. One said, we can't unravel this. Our system's been destroyed. Another said, the public will at some point rise up and demand justice. Well, the problem is we have lifetime appointed federal judges. We've elected judges. Okay. Do you think the electorate in Manhattan gives a damn what we have to say about anything? They're going to rise up and do a ticker-tape parade for these guys. So these are not serious answers. As an advocate, as somebody who has litigated against the left for 40 years, you got to do better than that. There's only one body that can save this judicial system, and it's the top judicial court in the country. You have to give it an opportunity to address this. It can choose not to. And then what's done is done. But you have to give it an opportunity. And when you're trying to save the country, Even if you have a 10% chance, isn't that good enough? It's not. You don't play a football game and say, I got to the 30-yard line and there's the end zone. Game over. Because the referee says, not the 30-yard line, that's it. No. We're going for the end zone. I've never heard of a battle in which you surrender and just keep whining about it. So, quickly, this is an important constitutional matter that raises incredibly important constitutional issues. That's what the Supreme Court's for. The extent of state court powers and the powers of a DA, this is crucial because we have thousands of DAs and assistant DAs and thousands of state judges, in Marchand's case, an acting judge yet. So whatever is resolved in New York doesn't resolve it for the country. That's number one. Number two, the Supreme Court cares about cases that affect the entire nation. This case affects the entire nation like no other case. Number three, we have precedent. The court stepped in Bush versus Gore under different circumstances and facts. But what does it tell us? It tells us that the court has a predilection to treating presidential elections differently than other activities, and that even though it's an exceptional case for the court to take up, these are exceptional times, exceptional circumstances that requires immediacy, not the lumbering process in the state court. So the president's lawyers ought to stick with that process for the purpose of preserving his appeals. But then we have the bigger issue, the presidency, federalism, due process, equal protection, the First, Fifth, Sixth Amendments, right off the top of my head. Equal protection. Our campaign is not on equal footing because of what happened in that courtroom. Joe Biden's able to run an unfettered campaign. Now the debate is, will the judge give Trump house detention? Will he require Trump to sign in every time he leaves the state for another state? In other words, this is an ongoing interference with the election. The unconstitutionality is ongoing. One state's decision, really, one DA and one judge's decision, should not affect the entirety of an election for all of us voters who don't live in Manhattan. The Supreme Court has the power in extraordinary instances to grant relief by use of common law powers. Are they rare? Yes. For rare occasions, yes. This is the rarest of occasions. So how does it work? Issuance by the court of an extraordinary writ authorized under 28 U.S.C. Section 165A. It's not a matter of right, but discretion, sparingly used by a court. To justify the granting of any such writ, the petition must show that the writ will be in aid of the court's appellate jurisdiction, that exceptional circumstances warrant the exercise of the court's discretionary powers, and that adequate relief cannot be obtained in any other forum or in any other form other than this court. You file the notice of appeal. As I said, you ask for a stay of the trial court from the New York court's immediate expedited review you seek. You file applications for common law writs, writ of prohibition, writ of mandamus. It doesn't really matter for our purposes. What you're trying to do is get the case to the door of the Supreme Court. You have 1,000 federal constitutional reasons for doing it. And the exigent circumstance is it's going on right now. The constitutional violations are affecting the election as I speak. Every minute that goes by, more damage is done. It becomes more difficult for the Supreme Court to undo it. I don't know why this is complicated. I don't know why people resist it. Well, it's a long shot. It may not work. So what? If you don't take a long shot, you take no shot. But it's not a coup process. It's just a different process. In Bush v. Gore, if the Bush and Cheney campaign had not filed a petition with the Supreme Court, we never would have had Bush v. Gore, would we? Here you give the court a different path, a common law. You seek common law writs, which is rare, but saved for these extraordinary circumstances. That's the point. I have no idea if the court will take the case, if it does or not. If it doesn't, you're no worse off than you were before. But there's so many serious constitutional issues that affect our liberties, that affect our voting system, that affect the presidential election process, that affect what I'll call reverse journalism, when a court steals the authority from the federal FEC or U.S. Attorney's Office. These are matters that must be addressed, not by state courts. It belongs in a federal court, and the only federal court that can take it and make a final decision is the U.S. Supreme Court. So why would you stop at the 30-yard line and say this is going to destroy the country? I don't know how we unravel it. We'll never get back. It's a sorry day. I surrender. I never surrender.
Want to see more Mark Levin? Go to levintv.com and subscribe now.